Periodically, bipartisanship will still fling off the Limbaughs and the Gingrichs and the other racists and the phobics and get back on its feet and say, this is too damn important for you children. The two lawyers who fought on opposite sides of the Supreme Court case, Bush v. Gore, joining forces now to fight against California's ban on gay marriage. David Boies, who represented Vice President Gore, and Ted Olson, who represented Governor Bush and would later become his Solicitor General, today announcing their partnership in filing suit in federal court seeking to have Prop 8 overturned. You will recall that yesterday, the California Supreme Court ruled to uphold the controversial ballot measure that defined marriage as solely between a man and a woman. The court letting stand, however, the unions of 18,000 same-sex couples who had married before the measure had been passed. Boies and Olson arguing that it is not a question of state law, but of federal law. To quote Mr. Olson, it's not about liberal or conservative, Democrat or Republican. We're here in part to symbolize that. This case is about the equality rights guaranteed to every American under the United States Constitution. Let's turn now to Nixon White House counsel John Dean, also, of course, former Associate Deputy Attorney General, now a FindLaw.com columnist and the author of both Worse Than Watergate and Broken Government. John, good evening.
Good evening, Keith.
As pathetic as the attacks on Judge Sotomayor might be at the moment, this is heartening stuff here, I would think, to you especially, that these two active partisans saying, you know, no, some things really do transcend partisanship.
It's delightful. It's very pleasant to see two intellectually honest men declare this what it is, which is a civil rights issue. It shows the outreach of the Republican right, on particularly the religious right, to make this into a wedge issue, notwithstanding the constitutional implications of it. So it's delightful to see these men get together in a common cause.
And the status of these two men within the legal community, what does that imply about the constitutionality of Prop 8 and other ballot initiatives in theory or in practice that might take a specific right away from a specific group?
Well, it speaks very strongly to it that if you honestly analyze what's going on, that indeed there is discrimination, there is a failure to comply with the Equal Protection Clause of certainly the federal Constitution is what they're going to argue here. It certainly applies in many state constitutions as well. So I think that you couldn't have a stronger team to present this issue, and we've got to applaud them for bringing the case.
Specifically relating to the presentation and the team, John, there's a statement out tonight from the ACLU and several LGBT legal organizations pleading to others not to file federal lawsuits about this, fearing that it could set back the cause of same-sex marriage because there's a fear that the Supreme Court would not yet be ready to rule in favor of same-sex marriage. Does that explain why we have not seen federal suits prior to this one?
Well, it certainly might explain why the ACLU and these other groups have not filed federal cases in the past, because there is a real danger. There is a risk involved in what Olson and Boies are doing. It will affect a lot of lives if indeed it doesn't go well. They're in a circuit that they should prevail in. It's a case that should ultimately go to the Supreme Court. And so it raises the issue of whether the court is ready or not. The ACLU and these other organizations have been going state by state. They've been using state legislatures. They've been using the ballot. They've been gathering information when they litigate, scientific information to refute some of the absurd arguments that are made in these cases of same-sex marriage and their implications. So I think their caution and concern is well-founded. And they're worried that going directly to the Supreme Court at this time, way before the issue might be ready for an institution that is not a cutting-edge institution, might be premature.
Speaking of the cutting-edge qualities to it and what the makeup of this Supreme Court is going to be, is Prop 8 likely to interact with the Sotomayor confirmation process?
I doubt it. You know, she may be asked the question. I think she'd take the traditional position that because it's an issue that's likely to be litigated before the court, she's not going to address it, although it would certainly be thrilling if she would, because I think based on her rulings in general as a circuit court judge and a district court judge, she's very fair. She believes in the equal rights of all, and she might, well, give some hint, but I think that would be a negative for her if she did.
John Dean, author of Broken Government and Worse Than Watergate, and a longtime friend of our show. Great thanks for that, and great thanks for your time tonight, sir.